Has ruled that in instances where a labour broker places a worker for more than 3 months, the client who the worker is placed at must absorb that worker as a permanent worker. This is a victory for casual workers who in the past have worked for years as temporary workers at the same firm. Well, to tell us more about what this ruling means, I'm joined on the line by Irvin Jim. He's the General Secretary of NUMSA. Thanks very much, Mr. Jim. So this is obviously a victory for casual workers, but just break down to us, in essence, what did the ruling say?
Well, you would appreciate that for years now, we would have waged a campaign as NUMSA and demanding that labour brokers must be banned. And we could not win a victory 100% because government would have taken a decision that instead of banning labour brokers, they will regulate them. And by regulation, this meant that if a worker is working for 3 months, he is deemed, that's the English that was used, he is deemed to be permanent. And we know that across sectors, in the mines, in factories, employers continue to not to effect this. And we, as a union, we took workers' money again, went to the labour court to basically demand that there must be an affirmation which is compulsory, that if you work for a labour broker, you are placed in a particular site, you must be made permanent. Whether you work for a labour broker or what, if you are in a job for 3 months, you must be made permanent. We won this victory I think it was 2016. We secured the victory, but these guys took us head on. They took it to Constitutional Court, and we had to go again to fight and defend. Finally, the ruling came today that basically all workers, after 3 months, workers must be made permanent. There's no such a thing that now workers will be abused. Basically, we think that this is bordering on it to be effective on banning labour brokers, because I don't understand who will continue to be sourcing work from labour brokers. They have become irrelevant, and therefore workers must be employed direct.
So, Mr. Jim, what about the issue of dual employment by a temporary worker? So previously what would happen, the labour broker would place the temporary worker with the client who also sort of employs them, and then that employer would be paying the labour broker, and the labour broker would then be paying the worker and also getting a cut from the services month in, month out. So going forward, how do you...
It doesn't mean that we would have to drop our guards. You know, they will try to do every trick. They can try now and place a worker before 3 months. They can try and remove him. But as NUMSA, we're there. We will watch them. What basically should happen is that if he places that worker and 3 months passes on, academically he keeps that worker in his books. But the bottom line is that that worker in that establishment must be made permanent.
So what would your advice be to workers who are not even members of NUMSA about what this ruling means for them?
Well, I mean, I think the first claim I should do and the demand I should be making for workers all over the country across all sectors, go to NUMSA offices, join NUMSA. It is your union. It's a union that workers must be proud to belong to. And the more workers join NUMSA, the more NUMSA should be strong. It must continue to be a worker control, to continue to take up more battles. That includes making sure that it continues with the fight to improve workers' benefits. And united we stand, divided we fall.
And then lastly, Mr. Jim, you say that you have a fundamental problem with labour brokers, but don't they have a role in actually facilitating employment, obviously not for a long-term basis, but actually matching employer and employee?
Not at all. All labour broker bosses must go and look for a job. They are lazy. They are not doing anything. It is workers' work, but they take the money. Within that, their time is over. Workers must be employed direct by employers and stay direct. And it's time for workers to basically, I think this is going to hit super exploitation that has been happening for years.
All right then, Mr. Jim, thank you very much for your time. That was Irvin Jim. He's the General Secretary of NUMSA. Let's take a look
Thank you very much.
You're welcome. Let's take a look at that judgment on the Constitution at the Constitutional Court.
Section 198(2) of the Labour Relations Act is identical to Section 82(1) of the BCEA. If the sole employer interpretation is followed, the client is the only employer for purposes of the Labour Relations Act, while the TERS remains the employer for purposes of the BCEA once the deeming provision is triggered. For all these reasons, Kachalia AJ would have upheld the appeal. The majority granted leave to appeal, but dismissed the appeal with cause. The following order is made. 1, leave to appeal is granted. 2, the appeal is dismissed with cause. I hand down the judgment accordingly.